Good morning, everybody. I hope you're having a lovely Monday and enjoyed your Halloween weekend. Just my leftover Thomas Jefferson wig, left over from Halloween. It was a little bit of a different Halloween than usual. We had our shoot to send the candy down, which really worked, I'd say 85 to 90% of the time, which was good. Our neighborhood is like Halloween craziness, and it was a lot less than usual, but it was still quite a bit of people, including a trespasser on our porch late at night that took like all the leftover Skittles, which was a little bit disappointing to everybody. I told the other class that I should have gone all Jacques V. Steenberg on them and really excluded them. But on a Halloween evening, I think that there's a lot of permissive. It's not permissive trespass. It's permissive inclusion onto property. How was you guys' Halloween? Anybody do anything exciting? No. Nobody had any really awesome like best ever costumes?
I ate candy.
You ate candy. Okay.
I dressed as a judge at my party and I gave out citations to people.
Yeah. Citations for what?
For having a big head, for having ugly shoes, just for some fun.
Okay.
I dressed up as like Legally Ginger.
Okay.
I'm blonde.
Got it. Good.
I got not on Halloween, but the day before Halloween, I got my flu shot.
All right. One year, so Halloween and flu shots are often connected, and Ben doesn't like shots, as many people don't like shots, and but he enjoyed the shot as long as he could dress up as a hot dog. So he put on a hot dog costume at Target, and we went and he got the shot while in the hot dog costume, which was only like the second funniest thing that happened that day. The first was that Sadie dared him to go up and ask a worker at Target. So the hot dog costume has ketchup across, on it. And she dared him to go ask an employee where the mustard was in the costume. And he did it. It was pretty good. But the employee was really good. He actually like walked him over in the hot dog costume to the mustard. Scott, you're getting a lot of heat over here in the chat. I don't know.
Yeah.
I don't know.
Well, I heard you already were told by Section 12, but I went as you. I have
So
a bundle
is
of
there
sticks, a few
no
watches.
photograph here?
Yeah, there's a couple. Let's
Okay.
see.
This is all very good for my ego. Oh, good. I see. Okay, we got the textbook in there. Nice.
There's a
I
bundle
can't
of
see.
sticks.
There's a glare.
They
Some
got the
text.
watches.
The watches, yes. Okay. I didn't understand the watches at first, and I was like, oh yeah, the watch thing.
I heard you weren't happy that I was wearing glasses. That's what.
Yeah. Well, if you're gonna do it, you got to do it.
Yeah, I
Right?
should have gone with contacts. That's on me.
Yeah. that's on you. Okay. Well, you pass, so you can just check out the rest of the semester.
Sweet, I was on
And,
call next case too.
Yeah. So we're good to go. Just so y'all know, that was not a binding contract. I don't know anything about contracts. I don't teach that class. I don't know anything about them, and so. But I know that what I just offered to Scott was not binding, so he hasn't actually passed the class yet. Okay. So, all right. So let's talk about these problems. I'm gonna take that off. It was just a good way. It was just a good way to to force the conversation towards Scott. The chat was the best part of this, in my opinion. Watching it just unfold over here. Okay, so we know what we know, and we're good with the present interests. But I want to make sure that we have an opportunity to work through some of these problems. Okay, so that's really what I have planned for today, is to work through these problems, and to the extent that we get through all the ones that we want to get through, then we can move into future interests. But so really, I want to open it up to y'all. Of the ones that we have yet to talk about, which ones do y'all want to work through in these problems?
Let's do number 9.
9. Okay. All right, Ashton. You worked through it with us. So Ophelia, the owner of a large ranch, is getting on in years, beginning to think about her estate planning. She's decided that at her death, she wants North Fork to go to her son Elmer for his lifetime. Then when he dies, she wants North Fork to go to the children of her sister Sarah, who are then to acquire complete ownership, draft a conveyance. So this is good practical practice. If you are a wills and estates lawyer, then what you will do is listen to a client tell you, this is what I want to happen, and then sort of make that happen, right? You'll ask questions like, well, what do you want to happen? You know, if this, then that, and whatever. And then you have to bring it to life, right? So you get their goals, and then you bring their goals to life. And okay, so Ashton, what would you do? What would you do here?
All right. So we'll start off with Ophelia. She's the owner of this large ranch, and she's beginning to think about her estate planning. Well, I'll go ahead and tell you the short answer is it's a life estate. But
Well, that's what you want to create. So how do you create it?
okay. What we do is it lasts. Let me read this. Let's see.
So this
The
one's
first
really
one,
asking.
for life, his lifetime.
Say it again.
Okay. I, Ophelia, grant this life estate to my son Elmer for his life.
Mm-hmm.
Then let's see. The third party. The third party, which would be the children of her sister. They would be the. Let's see. Would they be? They would be the remainder, and then to the children of my sister Sarah as remainder, who will then acquire fee simple once Elmer dies.
Right. So, I mean, I don't think it has to be that complicated. I think you're right on that. What you're creating here is a life estate for Elmer and a remainder to Sarah's children. But I don't think it has to be so complex in the phrasing. It can just be to Elmer for life, then to Sarah's children. Okay, so that will do the trick in terms of creating a life estate and a remainder. So Ashton, let me ask you a little harder question. So that accomplishes what Ophelia wants. Okay. Is
Yes.
there any reason that we should maybe pause before we create a life estate for Elmer and a remainder for Sarah's kids? Is there any reason that we might want to say, that does the trick, but if I was advising you, Ophelia, I would advise you to do something slightly different. Might you advise Ophelia to do something slightly different?
Maybe to grant a reversion so that she still has her own future interest.
Okay, so that's going to make it a little more complicated. I guess what I'm trying to get at is, if you recall in Baker versus Whedon, the grantor created a life estate, and it ended up being somewhat problematic years later.
Right.
And so we said at that time, well, you know, you created this thing, and it ended up that it was
Oh, I see.
frustrating.
I see.
Yeah.
What if her sister Sarah does not have children yet?
There's an issue there, right? That's a potential problem.
That's a
So
contingent.
let me back up. I just want everybody to hear. I think that to Elmer for life, then to Sarah's kids is a perfectly fine answer to this question. Okay, I think it's a perfectly fine answer to this question. What I'm pushing on is, okay, if you are the lawyer, ought you mention that sometimes creating a life estate causes problems later because life estates are very inflexible, right? So Elmer has this for life, and Sarah's kids, if there are any, right? Ashton's pointing out, well, there could be a sort of hidden reversion in here if Sarah doesn't have any kids. But if she does, then we have a future interest holder and a present interest holder, and they might come into conflict. And so in Baker v. Whedon, we talked a little bit about what might be done to avoid some of those problems. So, Ashton, any other ideas?
Let's see.
Just to provide another option to Ophelia. Something else here, I can do
Right.
this for you, Ophelia, but something else you might think about is what?
She could just do like a fee simple, and one of the other types that we had, like the fee simple subject to condition subsequent, so that
Could do that,
it's an
but that's
alternative.
going to make it more complicated. Scott, what do you think? What could we do?
I mean, just say directly. Oh, I'm not entirely sure.
Okay, Sky, what would you do? Just as another option for Ophelia.
Give it in trust.
Yeah. So why would you suggest that?
Because it simplifies what Ophelia can do with that while she is alive. It gives her like more freedom to do with it as she pleases.
Yeah. So it's just another option that gives a little bit greater flexibility, that avoids some of the potential issues that pop up when property is held in life estate and remainder. Okay. So Ashton's answer to Elmer for life, then to Sarah's kids, which creates the life estate and the remainder, is perfectly good. Then, but if you're going to be sort of a diligent lawyer, you say, well, some other things you might think about here that could cause this, these could cause problems down the road. We don't know where highways are going to be built, et cetera. And maybe we should put it in trust just to preserve greater flexibility. Okay. So I've never asked on an exam for you to draft a conveyance, but those are, that's the kind of things, these are the kinds of things that, you will encounter and need to be thinking about in life, in practice. Okay. Questions on number 9? We good? Okay. Who has another one that we want to talk about? Y'all got them all? Y'all are all set with the rest of them? Did we talk about number 12 in this class yet? Okay, or Dominique, do you have one?
Number 14. Well, we can
14?
do number 12 first.
Well, we're gonna do number 12 eventually, but let's do 14 first. Because it kind of connects also to the Baker versus Whedon case. Okay, so Dominique, here's the easy part of the question. Aunt Judy's will devise 200 acres of virgin woodland property to my dear sister Edith for life, and then to my favorite niece Natalie and her heirs. So what interests are created by that language?
So, Sister Edith has a life estate, and then the heirs, Natalie and her heirs have a remainder in fee simple.
Great. And so we can leave out the and her heirs language. It's Edith has a life estate, Natalie has a remainder. It's pretty straightforward. Okay. So then we're going to have this problem. 2 years later, Edith discovers that the timber on the land is worth a lot of money and wants to at least either sell the property or have some sort of arrangement in which the lumber is going to be cut down. Natalie, who, remind us, Dominique, what interest does she have?
She has a remainder in fee simple.
And can she go on the property?
If Edith is still alive, no.
Can she, if she goes on and straps herself to a tree and says, you will cut these trees down over my dead body, can she do that?
No, she'd be trespassing.
She would be trespassing. So she has an interest in this property, but not a possessory interest. Okay. So she objects to Edith making the deal, and but Edith continues on, and it looks like they're about to have this sale for $300,000. Dominique, what can Edith sell, assuming that the sale is to go forward?
Edith can sell her life estate.
And only her life estate. So Edith cannot sell a fee simple. She can only sell the life estate. So Tree Reapers must really like this $300,000. I mean, this property that they're going to pay $300,000 just for a life estate, because we know with a life estate, if Edith dies, then all of a sudden, whatever Tree Reapers has purchased is gone. Okay. And so what the question is asking is, from Natalie's perspective, what can she do? So Dominique, I'm going to split the answers into two categories. Category 1 is answers A, B, and C. And category 2 is answers D and E. A, B, and C are situations where Natalie can stop the sale of the property to Tree Reapers. D and E are situations where Natalie cannot stop the sale of the property to Tree Reapers. What do you think? Which one can we eliminate? The first group, A, B, and C, or the second group, D and E? In other words, can she stop the sale?
I think we can eliminate, and this is where I had the trouble, D and E.
Okay, so why? Why do you think that?
Because Natalie has only like, how do I put this? Only if Edith was wasting the land,
Mm-hmm.
she even kind of imposed something through the court.
Right.
So she would be a trespasser if she tried to impose anything else. So she can't do D and E.
So she can't do it physically. I think that's
Mhm.
right. But I guess what I'm asking is, can she, what gives her the ability to stop the sale? Because you said, I asked, what can Edith sell? And you said Edith can sell her life estate. Why would Natalie be able to stop her from selling the life estate? Does Natalie have any interest in the life estate at all?
No, she just has, not in the life estate, no.
Right.
In
So-
the remainder.
Right. So if the sale is going to happen, the sale is of the life estate.
Mhm.
So my question is, why can the future interest holder, let me ask you this. If Natalie wanted to sell her remainder to me, could Edith stop her from selling the remainder to me?
No, she could not, because
So
her
why
interest
can
is
that,
only in the life estate.
go ahead.
Because her her interest is only in the life estate.
Right. So why can Natalie, why in D&E is a situation where Natalie can get I'm sorry, you're eliminating D and E, right? You're saying that she can stop the sale, right? I just want to make sure we're on the same page.
Yeah,
Yeah.
Yeah.
So if Edith couldn't stop Natalie from selling her interest, why could Natalie stop Edith from selling Edith's interest? Because in A, B, and C, we have a situation where the court is stopping the sale, enjoining the sale. Where does that?
so they're stopping the sale because, as I'm understanding, the sale would lead to waste that would affect the remainder
So
in A, B,
good.
and
Okay. So what's the real issue? Is the issue the sale or what happens after the sale?
what happens after the sale. The sale doesn't matter. I think it's Edith can sell her life estate to whoever she wants, but the person who gets the life estate does something to depreciate the land, then what's her name? Natalie could step in.
Okay, I lost you about midway through what you said. I think what you said is Edith can sell to whomever she wants, but if the person who then gets the land does something to devalue it, then that's where the interests of Natalie are impacted.
Yes.
Yes, okay, and that's exactly right. So, but if the first clause you said is Edith can sell it to whomever she wants, then why are we eliminating D and E? I mean, why are we, yeah.
Could you repeat that? I think my connection's
Sure.
a little off.
Yeah, it might be on my end as well. So you said, and you're exactly right, Edith can sell the life estate to whomever she wants, right? So if that's the case, then why are we eliminating D and E? Am I still jumping around, Dominic?
No, I think I got what you were saying. But we're eliminating them because
So let me just, because
images.
it's like we've got like a triple negative and we're working with like
Yeah.
triple.
Mhm.
So it's a little bit confusing. In D and E, Natalie cannot stop the sale. Right? And you said that we need to eliminate those. And so my question is, that means that you think she can stop the sale?
No, okay. I think I'm just reading this backwards. I think that's what it comes down to. No. Natalie could not stop the sale, but she could.
Natalie cannot stop the sale.
Yes, I'm sorry. But she could get
Stop the
cutting of the trees or get some damages recovered. Yes. So yeah,
exactly.
that's double
The ones we need to eliminate are A, B, and C. Okay.
Yes.
In A, B, and C, she can stop the sale. My dog is going crazy over something. I don't know what it is. Toby. Oh, I know what it is. Hold on a second. You found it. Is that what you're looking for? Here, you want to see everybody? This pig makes this ridiculous noise. And so we had to move it away and hide it. And so it's been here in this room. But Toby just came in. Come here. And he sensed it. And he's going crazy. Say hi, Toby. So at least some person likes the pig. Toby likes the pig, but it makes this ridiculous noise. All right, so this is Toby. Say hi.
Hi, Toby.
He's the best. All right, so I'm putting you down. Here's the thing. Did y'all know there's also guinea pigs in here? Have I told y'all that? No?
Please show us the guinea pigs.
Well, I can't show you the guinea pigs because the room is a giant mess. And if I move the camera, then it will just be embarrassing and horrifying for me. So that's not going to happen. Guinea pigs are Ginger and Hazel. You can actually follow them on the Keel Pigs. They have an Instagram with over 1,000 followers. I think I'm not sure. Sadie runs it, something like that. So that'll probably ruin the rest of your day, or at least you won't be paying attention to me for the rest of this class. I'm going to ask y'all to drop your videos as much as I'm enjoying it, especially yours, Molly. The connection is getting kind of funky here. And it's always y'all's class at this time of day. It's very, very strange. I don't have problems in any other class. So it must be something about the timing. But Dominique, I'm sticking with you, okay?
Okay.
Okay, so we've eliminated A, B, and C, and we're down to D and E. And that's good because you're pointing out that this is a waste problem. And so the issue is that Natalie can stop any present interest holder, whether it's Edith or whether it's Tree Reapers or whether it's some other individual that's present here that the life estate gets passed to, from doing anything that unreasonably interferes with her expectations, right? She is the future interest holder. And is her interest uncertain, Natalie's?
No, her interest is certain because it's certain at some point Edith will die.
Correct. So hers is like the best kind of future interest that it could possibly be. It's definitely going to come to whoever holds that stick. In this instance, right now, it's Natalie. It's plausible that she could sell it, but let's just say that it's going to come to Natalie. And so she can't stop them from selling, but she can stop them from cutting trees, okay? And so that answer is which one, Dominique?
It's E, I believe. E.
E. So E, I think, is the best answer here. She cannot stop the sale. The future interest cannot stop alienation. They can't stop the transfer of the sticks from Edith to Tree Reapers or whomever. But she can stop this action that unreasonably interferes with the expectations of her, the future interest holder. And so, you know, if the trees had been being cut down prior to the life estate being created by Aunt Judy, then we might have a different situation. But here it's virgin woodland. And so, you know, it isn't happening. D is your second best answer. If for some reason Natalie is unable to get the injunction, she's too late or something like that, she could also get damages for the devaluation of property that results from the cutting of the trees. Okay, so Natalie, Dominique, did that address the question you had with that one? So it's all about waste.
Yes, it did. Yes, it did. I just misread the question, and now that's makes perfect sense now. Thank you.
Okay, great. So this is one that's all about waste, and it's all about the ability of a future interest holder to use the courts not to stop sales, but to stop wasteful behavior that diminishes the values of the property, or the value of the property. Okay. Other questions on this one before we go to the next? We good? Okay. I'm going to go to 12 now. So 12 is focusing in on, or let's see.
Professor Keel, can I ask quite quick
Yes.
question? I got a little bit lost in there between the guinea pig Instagram account and the different options that are available to stop the trees being cut. You did say that
Uh-huh.
the court can stop the trees before they're cut, not just award damages afterward, right? That's one of the options. Just wanna
Yes,
make-
that's E. And that's the best answer.
Okay, sorry.
It's just, so the reason I say D is plausible also is because Natalie, in this example, Natalie does care. She doesn't want the trees cut down, but it's plausible that Natalie actually doesn't. She just wants a cut of the money, right? And so if that's what Natalie is thinking, then her strategy might not be to stop the cutting of the trees, but to rather use the threat of stopping the cutting of the trees to get her cut of the money. Okay, but she definitely can get an injunction to stop the cutting of the trees in this instance. E.
Just to follow up on that, when you, if she were to file suit because of the trees being sold to this, because of the waste, can you specify like, I don't really have a problem with this waste, I just want to make sure that I get my cut? Or
You wouldn't say it in the lawsuit, but you would have your lawyer write a letter saying, look, I think I'm entitled to an injunction here. I'm going to pursue that injunction unless you pay me. It wouldn't be that crass, but that's the lawyering that would be happening in that instance. Does that make sense?
yeah, thank you.
Yeah. And that honestly, that goes to show, like in this example, it seems like Natalie really does want to stop the cutting of the trees, in which case she should pursue that. But it really just, that sort of second example where she just wants some of the money just goes to show that sometimes all the legal system is doing is affecting the negotiating power of the parties involved so that they can come to, so that the settlement will reflect their relative strength of their legal positions. And so that's constantly, that's a major reason that people file suits, is not because they actually want resolution of the suit, but because they know that they could get resolution of the suit, but they're using it as a bargaining chip in a longer negotiation process. Okay, so let's do 12. And 12 is asking about which of the following conveyances create a fee simple subject to executory limitation. Okay, and so we're going to just look at each of the three, remembering that the main thing that we are looking for with a fee simple subject to an executory limitation is that the future interest is given away. Okay, the future interest is given away. So it's got the language of defeasance and the future interest given away. And so I actually want to go through, in reverse order there. Okay. So let's go through them in reverse order. So the first one is owner conveys Greenacre to Cersei's and her heirs so long as the ginkgo tree presently growing on the property remains alive and in place. So it's, where did that go? So it's looking for a blue hand or someone who wants to work us through number 3. Go for it, Ryan. So what does this create? To Cersei's and her heirs so long as the ginkgo tree presently growing on the property remains alive.
So it seems like this is creating a life estate in a ginkgo tree.
Okay, we can't do that.
No. Well, no, it's okay. So I guess it's, let me see here. Let me go back to my chart. So it's going to be fee simple determinable, I suppose, right?
Mm-hmm. And
because
why?
it's so long as the tree is alive.
And so does it create a fee simple subject to an executory limitation?
No, it does not.
No, it does not, because who's got the future interest?
It's a possibility of reverter, so that's going to be the owner.
Exactly. Okay. So this one is a no. This one does not create a fee simple subject to an executory limitation. It's just a fee simple determinable with the possibility of reverter held by the owner. Okay. So pretty straightforward. 2C so long as whatever. Okay. It's just this 2A so long as X, 2 Circes so long as the ginkgo tree's there. Okay. Ryan, I'm going to stick with you for number 2. To Amelia
Sure.
and her heirs, but if the property is devoted to a use other than a wildlife park before the expiration of 21 years after Amelia's death, then to Brian and his heirs.
So this one seems like it does have the executory limitation placed on it. It's got the 2 Amelia and heirs, but that it's got the it's given away the future interest. But if the property is devoted, then it's going to.
Great. So Amelia has what interest?
Amelia has not what, possessory interest? Is that right?
It is a possessory interest, but we got to be more specific. Got to get one of these on the list.
Oh, so was it just fee simple subject to executory limitation?
Good.
Okay.
And Brian has
The future executory interest.
good. So the answer to this one is yes. Okay, so number 12.3 is a no. Number 12.2 is a yes. The hard one here is number 12.1. To Omar, when and if he marries. Omar currently not married. So you may have read, and I may have even mentioned this, that language that connects property rights to personal behaviors like getting married is generally disfavored. But I want you to just leave that aside for now. Okay. There are things like to Omar so long as he never votes, or to Omar so long as he doesn't convert from this religion, or things like that connect Omar's property interests to his personal liberty and autonomy. Okay, so there are reasons why, sort of as society, we don't want to enforce that kind of restriction, and restrictions on marriage or having children or something like that are another category of that. So this one might be vulnerable to that kind of criticism, but leave it aside right now. Just pretend that it says to Omar when and if he graduates law school or something like that, and he's currently not graduated from law school yet. So it doesn't really make much difference what the thing is. The main point is that it hasn't happened yet. Okay, so just asking sort of an open question to anybody, who has the present interest here with this conveyance? Owner conveys Blackacre to Omar when and if he marries. Omar is not married at the time of conveyance. So at the time of conveyance, who has the present interest? Scott, go for it.
Is it just the owner?
Okay. Good. And Scott, who has the future interest?
Is it also the owner and Omar? Or
It might
just
be. It
on
might be, but
condition?
let's leave the owner out of it for now.
Then just Omar?
Just Omar. Okay, so let's leave it at that. So that's helpful. We know that who can go on this property right now? Just the owner. When, Scott, can Omar go on the property?
Whenever he wants, or not, oh, when he gets married.
Once he gets married, right? Once he gets married, poof, the moment of defeasance has happened and Omar takes over in fee simple. Okay, so hopefully y'all can see the concept, conceptually that's the case. What's harder here is identifying what those sticks are. So owner has the present interest and Omar has owner and Omar. Gosh, that couldn't be worse. Owner has the present interest. Omar has the future interest, but what future interest and what present interest do they have? So Scott, let's walk through it. Let's start with Omar's interest, okay? Omar has a future interest. That means he has something on this side of the chart.
Would he have a right of entry?
Okay, so you're saying a right of entry. So where are you, why are you drawn to that?
Because it's just on the condition that he gets married, and it's like, instead of the condition being, I guess, on the owner here, it's on him. I can't see how it would fit anywhere else.
Good. So you're recognizing that, well, let's first say it's clearly not a fee simple, and because there's none. And it's clearly not a life estate because there's nothing that suggests anything about life estate. Okay. So that means you're recognizing that we've got to be down in the defeasible fees space. And you're saying it's a right of entry because it feels like once this thing happens, then Omar can step on. So let me ask you this real quick, Scott. Who can hold rights of entry? Who are the only people that can hold?
I guess the grantor.
Is Omar the grantor?
He is not.
Can he hold a right of entry?
I guess that he cannot.
He cannot. Okay, so it looks like a right of entry. It might even smell like a right of entry, but it can't be a right of entry because a right of entry can only be held by a grantor, and Omar isn't that. And we could go through and have that exact same conversation about a possibility of reverter. A possibility of reverter can only be kept by the grantor. Okay, so Scott, what do you think is the future interest? What is Omar's interest?
Guess that kind of just leaves executory interest.
This is the only one left, okay? And is Omar a third-party grantee or some other grantee?
No.
Hard to say, okay? So this is the biggest flaw in my chart is pointed out by this kind of question. So Scott is correct that Omar has the future interest and that interest is an executory interest. And if in fact it's an executory interest, then what must the owner have, Scott?
Well, I guess present interest and no future interest.
Worth no more than 8 points. You do not.
It is a present interest, but what type of present interest?
Fee simple. I guess subject to executory limitation.
It has to be, right? That's the only place on this chart that we're seeing that you can have an executory interest as your future interest is if the present interest is this, and that's correct. Okay, so the owner's got a fee simple subject to an executory limitation. Okay, so, but I asked that question, is Omar a third-party grantee? Surely doesn't feel like it. Surely doesn't feel like it. There's only two parties here, owner and Omar. That's it. Like there's no three parties, so you can't have a third party grantee as opposed to, you know, what you normally have, which is owner is party one to A so long as X, that's party two, and after X to B. B in that example is our third grantee, our third party grantee. We don't have that in this particular example. So the question then becomes, you know, like how is it? And like I said, this is kind of the flaw in the chart or a hole in the chart where a present interest holder or where a grantor keeps the present interest and gives away the future interest. Okay. And it's conditioned not on a life, but on something happening, right? Defeasance. It's an executory interest and a fee, whereas the owner is keeping, the grantor is keeping the fee simple subject to executory limitation. Okay, and I'm just gonna posit that we've actually seen something very, very similar previously. So if you think about Gruen, in Gruen case, the father gave himself a life estate and gave the future interest to his son. And we called that future interest a remainder. Again, not a third party. There's only two parties, the father and the son. And yet we called it a remainder. So perhaps that column shouldn't say third party grantee. Maybe it should say to someone other than the grantor, right? To someone other than the grantor. It's in those two, this example and the Gruen example, where the chart kind of has a little bit of hole to it, because in those instances, the individual who has created the interests has kept for themselves the current interest, the present interest, and created a future interest that they've given away. In this instance, to Omar. Okay, and so this one is actually an example of a fee simple subject to an executory limitation with Omar holding an executory interest. So the answer to this would be yes, it is an FSSEL. I will tell you, I write these problems, and sometimes when I'm going back and doing them, I still have a hard time seeing these fee simple subject to executory limitation. The characteristic you're looking for is when the language of defeasance. All right, so there's a few things. One, where there is only a grant to one person, but where the language of defeasance hasn't occurred. Okay, so it's only to Omar, and you got a fact that's telling you that the thing that has to happen hasn't yet happened. Okay, so those are kind of things that you should sort of have on your flag. You know, you just need to flag them. Okay, this looks like, right, when you know, like, let's say you saw something that said to Scott, so long as he graduates law school, right? So your first thought when you see to Scott, so long as he graduates law school, Scott, what's your first thought? If you just didn't think about it and I just gave you that conveyance, your first thought would be what?
I mean, honestly, I better graduate law school.
Okay, what's your second thought?
Fee simple, I guess like my first thought is like fee simple, determinable.
Yes, good. That's what your first thought should be. When you see to Scott, so long as he graduates law school, your first thought should be, oh my gosh, it says so long as. I don't even see a grant to a third party. This looks just like to a so long as. That looks like a fee simple determinable. But what's not, so we have a conveyance to one person, but the thing hasn't yet happened. And so the combination of those two things creates a situation in which the grantor has kept for herself a fee simple subject to executory limitation, and Scott has an executory interest in fee simple. So when, Scott, you do graduate law school, what will you have?
Just a fee simple absolute.
Great. Annie, yes.
Does this apply? Does the same exact situation and concept apply if the so long as were something that doesn't pertain to the particular grantee? Like if it's an event, like, yeah, well, you get what I'm saying.
Like that?
Sure, yeah.
Same. So it doesn't have to be something that the grantee can control. Okay, as long as it can't happen, it hasn't happened yet. Okay, but note the difference between this and like to Scott so long as he is enrolled in law school, right? So to Scott so long as he is enrolled in law school, which he already is enrolled, there Scott has the present interest, a fee simple determinable. Okay. Jack? Or Annie, did you have a follow-up?
No, I just think I'm getting a little bit turned around on like now the difference between a fee simple determinable and this particular situation. But you're saying just look basically for if the thing has happened yet or not. So the fee simple determinable will always be something that is currently happening.
Yeah.
Okay, but if that said, so long as he goes to law school, implying that he hasn't yet, then that's not fee simple determinable. Okay.
Exactly. Exactly. So you have to be attentive to the facts on the ground in order to determine if it's a fee simple determinable or if it's this kind of really sneaky fee simple subject to an executory limitation. You're going to see these more often, right? The sort of more straightforward one, where your first instinct when you see so long as is, oh, fee simple determinable, and then you're correct. But sometimes, and the real thing that, you know, I've given you like some characteristics that make it so, but the real thing that you need to ask yourself is the question that I think I asked Scott at the beginning about Omar. Can Omar go on this property? And he said, no, not until he gets married. And so the answer, that answer means it's a future interest that Omar has, right? So if it's a future interest, then it has to be on that side of the chart. And if it has to be on that side of the chart, it has to be an executory interest. And if it has, so you can kind of work it backwards in order to get to the answer. But you know, the question that you maybe would want to begin with is who can enter the property right now?
Okay, that's helpful. Thank you.
Jack, sorry.
I was going to ask if we could run through number 6 if we have time.
Yeah. Are there further questions on 12.1?
I was going to ask if the thing that's hasn't happened yet is a sure thing, like it's going to happen, or maybe pretty sure, like once this person turns 18, does that change it at all?
So if it had been to Scott, so long as he, I don't know how old you are, Scott, but if it said to Scott, so long as he turns 25, and it seems likely that he's going to be 25, that doesn't change it. It's still, until he turns 25, he is a future interest holder. As soon as he turns 25, he is a fee simple holder.
I guess to make this easier, like could a grantor like say it to me until, just to make it like simpler to read if they wanted to?
That is in fact what is happening. I, grantor, give to me, grantor, this property until Scott graduates law school. Okay. And at that time, I give it to Scott or something like that. It would have to be, you know, that's not a very good phrasing of it, but that's in effect what has happened. Okay. And that's why it actually is a third party, because the first two are the grantor and the grantor. They just happen to be the same person. And if that confused you, then just forget it, right? Just listen to the other stuff that I said. All right. Other questions on 12? All right, so Jack, let's go through this one. This one is a bit of a pain, but what it's going to require us to do is go through A, B, C, and D and determine the interests created and the effects of these facts. Okay, so the first one is from Lowers to Luke, so long as the land is used for a grocery store. So Jack, what did that create?
I think it created a fee simple determinable.
For Luke, and what else?
And then Lauer would have, oh wait,
Yep, Lauer would have.
Present interest.
Nope. Nope, Luke's got the present interest. You got that right. Fee simple determinable.
I guess the possibility of reverter.
Yeah. Okay, so they were the grantors in this example, and they have a possibility of reverter in fee simple. Okay, and the question is asking if Luke starts selling sports equipment. Okay, so if Luke starts selling sports equipment in this example, what happens?
So then if we, I guess, go back to Lauer's estate.
Yep, good. In fee simple, okay?
Yes.
So they had a possibility of reverter. It was so long as it was used as a grocery store. When he stops using it as a grocery store, boom, automatically the future interest takes, and Lauer's just has a fee simple, okay? So the question is asking, when will Luke hold fee simple? Does Luke hold fee simple?
He does not.
He does not. Good. All right. So B. Now here we have Luke conveying it to Lauer's with the understanding that the land will belong to Luke if he needs it for a sporting goods store. So who has what interest at the moment of conveyance? So forget that now he wants to turn it into a sporting goods store. At the moment of conveyance, what are the interests?
Yeah, this one, I was kind of confused as to which one it fell into.
Good. Why were you confused?
I wasn't sure what that clause meant. Understanding that the land will belong to Luke if he does the sporting goods.
Good. It doesn't sound like durational language. It doesn't sound like conditional language. Somebody help out Jack. What does this language sound like? Nobody's helping you, Jack.
It
Allie.
sounds like, sorry,
Or Kylie. I don't care.
it sounds to me like it's so long as, so fee simple determinable.
Okay, so you say it's so long as, but it's not so long as. It's with the understanding that. Hallie, what do you think it sounds like?
I was gonna say fee simple subject to condition subsequent, because it
So
seems
you think
like,
it sounds like conditional language, and I don't think it sounds like conditional language. So Kylie thinks it sounds like durational. Hallie thinks it sounds like conditional, and I'm telling you all, it's neither of those things. What is with the understanding?
Is it just a promise?
It's a promise. It's promissory language. And does promissory language create property rights?
It does not.
It does not. It creates contract rights. Okay. So this is an example like we saw in one of the problems from the book from last week. I don't have it in front of me, where the conveyance to Lauer's is of a fee simple, and then there's contract agreement, maybe ... Okay. Contract, I'll even put a question mark. Okay. So this is a fee simple to Lauer's, and to the extent that Lauer's has any obligation, it's just enforceable as a contract. So Jack, now he wants to sell sports equipment on it. Does he get a fee simple?
Not automatically.
No, not automatically. Why not?
It's a contract issue, not.
Yeah, that's a contract issue. Great. Okay, so B, no, it is not B for the for that reason. Okay, Lauer's has the fee simple. Luke certainly doesn't. To the extent that they're going to have some sort of conflict here, it's a contract problem. Okay, now C. From Lauer's to Luke, provided that he uses the land for a grocery store, but if the land is not used for a grocery store, then to Luke's son, Tom. Okay, so Jack, what do you think we got here?
I think it's a fee simple subject to executory limitation.
For who has that? You're right. You're right. And I've already
think
put it
Luke
up
would
there.
have- Luke would have that.
Look, right. Okay. And then what other interests are there?
Lowers would have the executory interest.
You sure it's Lowers?
Or no, I'm sorry. Tom.
Mm-hmm. Okay. So if he starts to sell sports equipment, in other words, doesn't use it as a grocery store, then what happens?
Then it would go to Tom
In what form?
in fee simple.
Good. So it's not C. So it's D. That's the answer. We can move on. Or do you want to know why it's D?
I thought it was either B or D. So
Yeah,
I think
it's D. Let's work it. Let's work through D. Okay. All right. So, and this is just, it's just kind of mean, D. Luke once owned in fee simple, and then Luke conveyed it to Lowers while I operate my grocery store there. What does Lowers have?
He's got a fee simple determinable,
Great.
I think.
Okay. And what other interests are there?
And Luke holds the possibility of reverter.
Great. Now, this is the mean part. Lowers Real Estate then conveyed a life estate to Luke so long as he sells tennis balls on the property. Okay, I want you to forget that for a second. When he stops operating the grocery store, what happens?
Let's see. That one's automatic, so it would go to Luke in fee simple.
Great, and that's what the question is asking for. This Lowers Real Estate conveys a life estate to Luke so long as he sells tennis balls is only meant to confuse, okay? The answer is straightforward, independent of that,
Okay.
okay? Could Lowers do that? Of course, they can. They can do whatever they want with the sticks they have, but the sticks that they have are a fee simple determinable. So whatever they lease to anyone, whether it's Luke or someone else, it's still subject to that same language while I operate my grocery store there. And so if he stops operating the grocery store, then his possibility of reverter kicks in. There is no situation in which this would be happening in real life, okay? This is really just a way to sort of force you into following the ins and outs of particular conveyances and identify the sticks that are present. Okay, so it's D. D is the answer.
All right. Thank you.
You good with it, Jack?
Yes, sir. That makes sense.
Okay. Other questions on 6? Any others you guys want to speak about on these worksheets?
Could you go over 3 on 11?
Who's talking?
It's me, Logan.
Okay. Which of the following conveyances create fee simple determinable estates? Let's just look at number 3. To Carlo for the purpose of growing soybeans. So what do you think? Is that a fee simple determinable?
That's what it sounded like to me. It reminded me of that case with giving the land for school purposes,
Mm-hmm.
but wasn't entirely sure.
And why not?
Just
What was holding you back?
Just because the language was different.
Language is different. So if it's not a fee simple determinable, what else might it be?
I guess just a fee simple.
Okay, so it could be a fee simple, and then what's with this for the purpose of language?
I guess I don't know if it's technically considered binding though. I guess it kind of sounds like a contract agreement. Like you can use it for this, but there's
The
no
main point
there's
is
no-
not so much, so good. I like how you're thinking about it, and I think that that's right. The answer here is no, it's not a fee simple determinable. And the reason is because the language doesn't create it, isn't language of duration. Maybe I could get on board with what you're saying, that this, for the purposes, for school purposes only, from the Marenholtz case, which eventually was a fee simple determinable, maybe I could get on board with that. But the reason that case was so difficult was because the language was so bad. It was just unclear. And here, so too, we have the same kind of language problem. And I just, I heard Logan, you saying, I'm not sure if it's binding. That's not important for our course, okay? Whether or not it's a binding language, it might be important for us in the second semester when we start talking about easements and covenants, so contracts that actually can be stuck onto the property. But here, it's the main point is that the ownership of the property is not dependent on how the property is used. How the property is used might be, between owner and Carlo in this example, but this is that's just promissory language, not durational language or conditional language. And so therefore it is just a fee simple with a promise attached or with an understanding attached. So it's just like that other one in 6B, right? With the understanding, for the purposes of, those kinds of phrasings do not create defeasible fees, do not create fee simple determinables or fee simple subject to condition subsequent or fee simple subject to executory limitation.
Gotcha. Thank you.
Yeah, got it. Great. Yeah, Annie.
Could you just clarify what conditional language is? Then I'm getting a little mixed up with that as well. If the
Yeah.
for the purpose of is not conditional, what is conditional?
On condition that, 2A, on condition that it be used for growing soybeans. 2A, provided, however, that if it is not used for, provided, however, that it be used for growing soybeans. 2A, but if it's not used for growing soybeans, then back to owner.
Okay, so for the provided, however,
Mhm.
I'm interpreting that as the same thing as for the purpose of.
Yeah, and I'm just telling you it's not.
It's not. Okay.
Yeah.
Should I just memorize certain phrases?
I'm telling you, for our exam, you need to know so long as, during, while for language of duration, and on condition that, and but if for language of condition.
Okay, so
those are the magic words.
Go outside of that.
Not on the conveyances, no.
Okay, that's what I'm mainly just worried about, but that.
Yeah. If I do, guess what I'm trying to test you on?
My vocabulary.
No. If I say to A who promises not to grow, or who promises to grow soybeans forever, what is the point I'm trying to drive at with a conveyance like that?
It's just a promise.
Exactly. So
Okay.
to the extent that you've come across something that doesn't have the magic language and isn't a life estate, what I'm pushing for is this exact point that we've been hitting the last couple minutes, which is that if it doesn't use the magic language, it's just a promise, it's just promissory language, and that does not create a different property right.
Okay, I
Okay.
feel a lot better about that. Thank you.
Yeah, Hallie?
I just wanted to make sure I got what you said. So you said the so long as and during and while are all duration language. And then on condition that and but if was what kind of language?
Conditional.
Okay. Thank you.
Mhm. Any other ones? I'm gonna thumb through and see if there's any that I really want to talk about. Did we do 8? Or Zach, sorry.
Oh, I wanted to clarify. I can ask this after class, but when you went over 12, option 2, I just wanted to clarify what that one was. I know that 1 was the answer. That was the
No, 1 and 2 were the answer. So
Okay, so
they
2.
were, yeah.
Okay. I thought 2 was. I just want since
Yeah, they were both like check. Yes, they are fee simple subject to an executory limitation.
Okay.
It's not the best phrasing of the question.
Okay.
There were more than 1.
Okay. That was my confusion. Thank you.
Okay. Okay. Have we done 8? I don't think we've done 8. Let's do 8. I can't see y'all shaking your heads because you're all gone now. Okay. So Mountain Realty Company conveyed 10 acres of land to Elaine for life. So who wants to walk us through it? Anyone? Scott, you want to do it?
I can give it a shot, yeah.
Okay. What is it? To Elaine for life.
So Elaine has a life estate.
And what else is created?
Drafted. And then I guess Randy would have remainder interest.
Nope.
Or
read the first sentence. Don't worry about the what happens after the first sentence, just the first sentence. To Elaine for life creates a life estate for Elaine.
And I guess just a reversion for the Mountain Realty Company.
Great. It's a reversion for the Mountain Realty Company, right? They don't give away the future interest to anybody. Okay. Now, 2 years later, so I just want everybody to hear, that's all this is. Elaine has a life estate and Mountain. 2 years later, Elaine drafts a will devising all of her property to her son, Randy. Does anything go to Randy at that time?
No.
No, why not?
Because Elaine's still alive.
Still alive. So could she change her will the next day?
Yes.
Great. Okay. Then Randy sold his interest in the land to Sarah, so long as she doesn't allow an SUV to enter the property. What interest does Randy have in the land?
None.
None. So what did Sarah get?
Nothing.
Nothing. You can sell all the sticks you have and none of the sticks you don't. So what is the effect of that sentence on this property?
None at all.
0. Okay. Next, Elaine sold the land to the county for use as a park. What can she sell?
Her life estate.
And so what did the county get?
I guess the 10 acres for Elaine's life.
Great. 10 acres for Elaine's life. So then finally, Elaine dies. So what happens to the county's interest?
It reverts back to the Mountain Realty Company.
Great. And so who owns the possessory interest in the 10 acres of land?
Mountain Realty Company.
Mountain Realty Company in fee simple. So that question is there so that you will trust yourself Okay. This is a very simple conveyance. Elaine has a life estate. Mountain Realty Company has a reversion. That's it. All this other stuff that happens, don't let it be confident, right? Like, I know what a life estate and a reversion are. So this is for all, for all of you. Be confident that what you're doing, that you know what you're doing. And all this other stuff about it, Will and Randy and Sarah, so long as an SUV, like, oh my gosh, it sounds so complicated. Well, don't make something that isn't complicated into something that is complicated if it's not appropriate. Here, it was pretty straightforward from the beginning. You knew from the beginning that as soon as Elaine died, Mountain Realty Company takes as fee simple. And all of this sort of noise that's happening in between the first sentence and the second to last sentence, finally Elaine dies, all of that is just noise. And you'll have to read each sentence and say, okay, does that sentence actually mean anything? Sometimes yes, sometimes no. But if you trust in your sort of initial articulation as what, then you should be able to follow each step as it has, sometimes slowly and deliberately. So don't get caught in the noise. Okay? All right. We'll pick up on future interests on Wednesday. Scott, thank you for being a good sport today. And I will see you guys then.
Wait, Professor Keel, I was gonna ask, what did Randy get from that will? The will mentioned that he gets the property, so what would happen?
He did not get anything that had to do with this 10 acres.
Okay, so even though the language shows or suggests that all the Elaine drafted a will dividing all the property to her son, that does not include the 10 acres.
It can't, right? She has a life estate. So if it's a life estate, then is it included in what she can will away?
No.
No, because as soon as she dies, it's gone from her. And so since it's gone from her at that time, a life estate will never be included in a life estate that I'm holding, that an individual is holding, can't be passed through their will, because it's, you see what I'm saying? It just doesn't work.
Yeah, I do. Gotcha. Okay, thank you.
Oh, Professor, I had a quick question. So 14
Yes.
was E. 14 was E. Or
Best answer in 14 is E. Yes.
okay, thank you.
You're welcome.